You've worked with factums in the course of preparing for your moot, so you are somewhat familiar with their structure. In this session, we will look a bit more closely at the factum's component parts. One thing to keep in mind is that a factum is either a permitted or required part of a legal proceeding before a court or tribunal. Within the rules of civil procedure for Ontario, for example, there is a rule that requires an applicant to serve a factum along with an application record for applications. Other tribunals, such as the Human Rights Tribunal of Ontario, do not specifically require the delivery of a factum, but will permit parties to submit it. It is always important to check the procedural backdrop for your factum, because sometimes the rules will say that it must contain certain specific parts. The factum, of course, expands on the claims in the notice of application, or notice of motion if it happened to be a motion. It is an opportunity to provide a judge or adjudicator with a better sense of how the law and facts work together to support your position, and it is a map of how your argument unfolds. Note the quote on the slide. A factum not only speaks to a judge first, it often speaks last. When the court reserves judgment, the factum remains a silent advocate for your position. And this author says, I often make heavy use of a good factum when I write reasons. So, keep in mind, you will leave the court or tribunal after you've done your oral submissions, but your factum will stay with the decision maker. So again, borrowing from the rules of civil procedure, let's take a look at the fairly straightforward format for a factum. Header, overview, facts, law and argument, and order requested. Beginning with the first paragraph of your overview section, you should start numbering the paragraphs of the factum consecutively. Now, let me go through each part in a little more detail. This heading follows the standard format provided by Form 4A in the forms linked to the rules of civil procedure. The standard format involves a court file number in the upper right-hand corner. This number is issued by the court. It is not something that parties themselves create. Then we have the name of the court or tribunal, followed by the names and titles of the parties. In this case, Forahan Limited is the applicant, and Sonia Green is the respondent. Then we have the name of the document. Here, factum of the applicant, Forahan Limited. Another example, as you can see, the format is the same. The information is different. Now, turning to part 1 of the factum, the overview. Most people who do a lot of written advocacy agree that whether the factum rules that you are dealing with call for an overview, you should provide one. This is where you make your first persuasive statement about your client's case. You set out briefly what the application or motion is about, what the key facts related to the proceeding are. Note you're not giving all of the facts here, just the ones that are key to understanding the essence of the matter. Your client's position follows, and where appropriate, a brief statement aimed at motivating the decision maker to grant the outcome your client is looking for. Let's take a quick look at an overview section from a previous legal process moot factum. It's a bit more detailed than some others because of the various decisions that were rendered before getting to the motion that the Osgoode Superior Court of Justice was being asked to deal with. The first paragraph sets out the beginnings of the matter, an unsuccessful claim by a father to terminate child support for an adult child who had a disability that rendered her unable to continue to attend school on a full-time basis. Then we had his appeal of the judgment refusing to terminate his support obligation, and a responding unsuccessful constitutional challenge by the mother to the legislation at the root of the question of whether the child at issue was entitled to continuing support. The unsuccessful challenge was unsuccessful because the court that heard it actually dismissed the father's appeal, finding that it did not need to rule on the constitutional issue. Next, we find out that the father appealed again, but then that his appeal was dismissed as abandoned, while the mother wanted to continue with her cross-appeal and the determination of the constitutional questions. Finally, we find out that the government wants mother's cross-appeal to be dismissed as moot. Note, starting at line 5, the mother's position on the government's proceeding, the government's motion. Ms. Bender opposes the motion. Then we see a bit of a motivating statement about the impact of the current law on vulnerable individuals, adult children with disabilities, and their caregivers. So this particular subject matter is quite suited for motivating statements rooted in social policy. Certain subject matters will lend themselves more readily to a natural insertion of such a motivating statement. Turning to facts. While a memo calls for a completely objective articulation of facts, a factum requires that you present facts in the most persuasive manner possible for your client. This means emphasizing positive facts and minimizing the impact of negative ones. Now, please don't take me to say that you are allowed to sacrifice integrity and accuracy. You are not. And you must also be careful to refer only to material facts. If your factum has a large number of facts, dividing them under subheadings may be appropriate. Your objective is to make the document as easy to read as possible. I thought the quote from the Writing Effective Briefs article provided a good description of the balancing that counsel must do when articulating the facts. First, being accurate, yet presenting your case in the best light, and second, getting all of the relevant information out while being concise and pointed in doing so. As the author notes, good counsel manage these tensions in a way that is fair and ethical, but nonetheless results in a version of the facts that leaves the impression that their client should prevail. The Rules of Professional Conduct for the Law Society of Upper Canada also provide guidance that is relevant to persuasive writing. Note Rule 5.1-2 on the slide, which provides that a lawyer shall not, and if you look at item E, knowingly attempt to deceive a tribunal or influence the course of justice by offering false evidence, misstating facts or law, and a number of other items that are not of particular focus for the purposes of this discussion. Item F, must not knowingly mistake the contents of a document, the testimony of a witness, the substance of an argument, or the provisions of a statute or like authority. G, must not knowingly assert as true a fact when its truth cannot be reasonably supported by the evidence. And I, must not deliberately refrain from informing the tribunal of any binding authority that a lawyer considers to be directly on point and that has not been mentioned by an opponent. So it's important to keep those parameters in mind in creating your factum. Just a word on facts and word choice. Of course, the unique aspects of each case will dictate how the facts may be presented most persuasively. But consider the difference that the word choice makes in the example on the slide. In the first option, the message is quite neutral. The government wiretapped defendant's telephone. In the second, home telephone is more personal and is aimed at making the reader react to the notion of the invasive quality of wiretapping a home phone. And then the third example is arguably over the top and probably loses the reader. So again, it's a matter of achieving that balance. Just as there is a CREAC formula for memo analysis, a similar approach applies to making your argument on each element of your submissions. So first, figure out which points you need to make to support your theory of the case, and then, for each point, what you want to do is provide the conclusion that you want the court to reach, a concise statement of the principle that you are relying on in support of that conclusion, an indication of the related facts, and your position about how the law and facts interact to allow you to assert the conclusion that you're suggesting the adjudicator or judge ought to reach. Sometimes you can do all of that within one paragraph if you've got a relatively concise point that you want to make. We'll see an example a bit later of situations where you need to develop your point and your support for that point over the course of a number of paragraphs. But here's one where everything fits into one. Dr. Pink met the required standard of care. Well, that's the conclusion that you want the decision maker to reach. The standard of care required of a medical practitioner is that of a person professing to exercise that skill. That's a legal principle from a case called Freyern Hospital Management Committee and Dobbs. Then we get an indication of the facts. When Dr. Pink diagnosed the plaintiff with epilepsy in 1999, he did not profess to exercise a skill over and above the skill of the ordinary competent physician of his time. And then your conclusion about how those facts link to the principle is that this is the standard against which his diagnosis must be assessed. So you can see that the formula is not all that different from the analytic approach that you have learned for previous writing assignments. Okay, so here's an example where we use separate paragraphs to set out the elements of proving your position. Note that these excerpts are taken from actual facta, and in some cases the citations are not consistent with the current citation guide requirements. So, this factum relates to the question of whether an award of solicitor and client costs is appropriate in relation to the particular proceeding that had taken place. Note that solicitor and client costs would be the same as what you have probably learned about as substantial indemnity costs. Okay, so we start with a paragraph that sets out the party's position. An award of costs on a solicitor and client basis is not justified in the circumstances. And then you see a statement of principle. Costs on a solicitor and client basis are the exception and not the rule, and should not be made unless some form of misconduct on the part of an unsuccessful party is found. Moving to the next paragraph, we get a specific and more detailed case example that provides more explanation for the rule or the principle that was established in the paragraph before. And so if you think back to CREAC, this is quite similar, where you have a statement of the rule and now a case that explains it more fully. Then we move into the tie-in with the facts, or the application to the facts. The Attorney General of Canada was successful in all aspects of this application. There's no suggestion of misconduct. And then we have the final sentence, which says essentially there's no basis to order costs on a solicitor and client basis in this situation. Note that headings are quite important in the art of persuasion within a factum. We generally talk about using thesis-like headings and subheadings. And so if you take a look at the examples on the slide, consider how much more informative the first one is than the second. So the first, McCombs J, erred by considering the court challenges program, as opposed to obligation to pay. The second doesn't really tell the reader where the author is going, where the first does. Another quick note about headings: in writing effective briefs, we get a bit of a discussion of this topic, and the author notes that headings should be short and understandable at a glance. And the first example provided is not short. The second is much better. Still thesis-like, spousal support should not have been awarded. It's very clear what the position is, but very succinct. This is all about point-first writing, making the point and then supporting it. Headings and subheadings can facilitate that point-first writing approach. And so, a short example on the slide: Ms. Green is a vexatious litigant within the meaning of the Courts of Justice Act. And then you get a discussion of why that position is defensible in the paragraph that follows. Other tips to keep in mind: don't overstate your own case, and don't demean your opponents. Strong advocacy is not about being disparaging to others. It's about asserting the strength, the legal strength of your particular claim, and of course, any policy motivations or rationales that support your position as well. In terms of thinking about word choice, avoid legalese, but don't write too casually. It is a fairly formal document. Now, one of the things that used to happen quite frequently was that factum writers would use the phrase, "it is respectfully submitted," frequently. Unfortunately, that seems to be falling away in current factum writing. But if you happen to come upon a precedent from a while back, and you see this phrase used in virtually every paragraph, avoid the temptation to follow that trend. The place that we do tend to see the respectfully submitted phrase is at the end of the relief requested, and the relief requested, of course, is the last part of the factum. So here we simply indicate what the party is requesting, and where relevant, what sort of costs they're asking for. Now, for example, in a human rights tribunal claim, you're not looking for costs, but in a civil proceeding in the Ontario courts, often you are asking for costs. So you end with all of which is respectfully submitted and the date that submission is occurring, followed by counsel, name, and signature.